My name is Crystal Schimpf, and I'm your host and presenter for today's webinar, Protecting Patron Privacy, Library Policy Development. And today we're going to look at the importance of patron privacy in libraries and how policy development can help protect both the rights of library users and the integrity of the library. I'm a consultant at the Colorado State Library, and that's a division of the Colorado Department of Education. I primarily work with public library boards and directors, and I started my career in libraries as a public librarian, and I've been providing training and consulting for close to 10 years now. Patron privacy is a topic that I am particularly interested in, and I believe it is of critical importance to library access and to democracy. This webinar today is part of our series for Colorado Public Library trustees. And I know that it's a topic of interest to people in many areas of library work and library service. So thank you for joining me as we discuss this important topic today. We'll start off by looking at our legal and ethical responsibilities, and just to let you know, you'll receive some additional resources later on that include detailed documents and also some legal references so you can review them later. Those will arrive in your email box at some point tomorrow, along with the slides and a link to the recording of this session. So we'll start off with those legal and ethical responsibilities, and then we'll look to some guidelines for patron policy development, and also some free resources there that are available to help you. I'll share a few model patron privacy policies from Colorado libraries, and then we'll close with a mini panel including a few leaders from our Colorado public libraries. I hope that this session helps to better prepare you in tackling this subject at your library. And also, since this is a webinar today, you'll be able to participate in the chat, which is in the lower left corner of your screen, but your microphones are muted today. I have several opportunities for you to respond during the session, and I hope you will post your questions and any comments in the chat as we go along. You'll also notice sometimes that I read some of what you see on the slide, and I just wanted to let you know that is both for the recording and also for audio accessibility, so don't be alarmed if you notice that. And just as a reminder, we are recording this session today. Now, another quick disclaimer just before we begin. I'm a librarian and not a lawyer, so the facts, the information, and the links provided in this presentation are for educational purposes, and they're not intended as legal advice, so they should not be used in place of seeking legal counsel from an attorney should you need it. All right, so let's start off looking at the legal and ethical responsibilities we have in library work. Now, the right to privacy is essential to intellectual freedom, and it's a foundational principle of library service. Without privacy, our freedom to read, our free speech, and our free thought are all in jeopardy. Privacy is addressed in the Constitution, in the Library Bill of Rights, and Colorado library law, and we will explore those in just a moment. Public libraries should also have policies in place to further protect patron privacy. These policy documents communicate to the public, and they provide guidelines for staff for handling situations that threaten patron privacy. Now, before I get into those legal and ethical responsibilities in those documents, let's just take a moment to reflect on our own experiences. I'd like you to think for a moment about the way that, that we think about privacy today in this digital age that we live in. How has our right to privacy been diminished in today's world? And you can share your responses in the chat, and you can be brief if you'd like to. So just think about that for a moment and share any responses you have in the chat. And I'll give you just a moment on that. Yeah, so just thinking, how has our right to privacy changed? How has our thoughts around privacy, how has that changed in our world today? And I see some people are typing now, so I'll wait for your responses. Right, so I'm seeing social media. Of course, the way we interact with social media is changing the way we think about privacy, and of course the way those companies that do social media handle our privacy. I see big technology companies selling our data. We no longer control our own information. a fair point here. It's a leading question. One could argue that our rights to privacy have been improved through technology. Surely we could debate that. Seeing that requirements to use personal information to access software are required for work. We've given up our privacy for security, right? So valuing security a little bit over privacy and willing to give up some of that. I think about the way we hand over our information through a grocery store or frequent shopper cards to Amazon, for example, with our online purchasing or other providers of online goods. Things like smartphones and smart speakers that we have that are tracking us in our movements. And also thinking about the way that privacy is regulated or legislated. And so there are many different ways that our perspectives on privacy are changing. And I would argue that libraries are a place where privacy is held at such a high value and is so important to the work that we do. We don't want to let go of that privacy protection. So a good place to start looking at our responsibilities when it comes to privacy are to look at our constitutional rights. These are foundational to library privacy ethics, and they are the kind of essential underpinnings of our democracy, or some might say that. And so looking to the First Amendment, which addresses our right to free speech and free association, and the concept of intellectual freedom, the right to read and to view any information. Our Fourth Amendment addresses our right to privacy, in particular our right to not be subject to surveillance when there is a reasonable expectation of privacy. And our Fifth Amendment addresses our right to due process. And this is particularly important when we think about someone who might be under investigation for criminal activity. We all have a right to due process that is followed in order for justice to be served and a fair process to be served. Now here in Colorado, we have a strong law protecting the privacy of library user records. And so this section of the law is shared in the resources which you will receive. But I would like to take just a moment to read through this together since it's pretty short and it's really critical to our work. So the first section of this part of the law says, except as set forth in subsection 2, a publicly supported library shall not disclose any record or other information that identifies a person as having requested or obtained specific materials or service, or as otherwise having used the library. So that's a pretty broad definition of what's covered. And then if we look to Section 2, these are the exceptions. Records may be disclosed in the following instances: when necessary for the reasonable operation of the library, upon written consent of the user, pursuant to subpoena, upon court order, or where otherwise required by law, or to a custodial parent or legal guardian who has access to a minor's library card or its number. And it goes into a little more detail there about electronic access. And then in Section 3 of this part of the law, it actually states that any library official, employee, or volunteer who discloses information is in violation of this section. That's a Class 2 petty offense, and they shall be punished by a fine of not more than $300. So there's actually, this law is weighted with a fine and an actual offense. And so it is so important to the work that we do. Now, if you're already thinking of questions to ask how to interpret this law, you're not alone. What does it mean to be necessary for reasonable operation of the library? Or how does one get written consent of the user? These are answers that can be clarified through local policy and with the guidance of legal counsel. Now another document, the Library Bill of Rights from the American Library Association's Office for Intellectual Freedom outlines the patron's right to privacy in the library. Now the Library Bill of Rights was originally drafted and approved by members of the association in 1939, and this clause was added in January of 2019 because of increasing importance of patron privacy in our profession. And it states, all people regardless of origin, age, background, or views, possess a right to privacy and confidentiality in their library use. Libraries should advocate for, educate about, and protect people's privacy, safeguarding all library use data, including personally identifiable information. Now, a related document to this that comes from the ALA is their interpretation of the Library Bill of Rights specific to privacy. This is 4 pages. It's a bit longer. It goes into detail about why this matters to libraries, and it includes some legal, policy, and procedural considerations for libraries to be aware of. And so I'd like to just call out some of the statements that are most meaningful to me. Privacy is essential to the exercise of free speech, free thought, and free association. A lack of privacy and confidentiality has a chilling effect on users' selection, access to, and use of library resources, meaning that if you don't believe you have privacy when accessing the library, it will chill your use of the library and the information contained within. And lastly, all users have a right to be free from any unreasonable intrusion into or surveillance of their lawful library use. So those are some critical phrases for me, and if you read that document, you may find some that speak to you or that may influence your policy decisions at your library. Another couple of laws that are actually state laws that kind of tie loosely to patron privacy, or at least relevant here. In 2019, Colorado's state legislature passed a law that enacted strict protections on consumer data, and particularly data that was considered personally identifiable information. And as part of that law, all government, commercial, and nonprofit entities that collect any data about their constituents must enact what they call reasonable security measures to protect that data, and also to have a plan for notification of individuals if and when a security breach occurs. Now, additionally, it requires entities to have a policy in place about the disposal of data when it's no longer needed or when it's no longer required to be kept by law. And this data disposal policy can be part of a larger policy, or it can stand on its own. And the State Library published a fact sheet on this topic, and the link is going to be included in the resources you receive. Another state law that relates in some ways to patron privacy and must be considered is CORA, the Colorado Open Records Act. And briefly, this law states that all public records shall be open for inspection by any person at a reasonable time, except as provided for within the law. Now, without going into detail about CORA itself and its open access provisions, it's important to note that library user records are protected by law, as stated earlier, and as such, they are specifically named as an exception to the CORA requests. So, if a member of the general public requests access to patron records of any sort, that request can be declined. And be sure to talk to a lawyer about how to handle this situation if it should arise. So now I have just a few examples to share with you, and then I'm going to ask you if you have any examples to share with me. So the first one is an example based on a real case that came out of Washington State. And this is a situation that does happen occasionally, and it's good to be prepared for it when it does. A law enforcement officer came into the library and presented a court order requesting some information about patron use of a particular item. So they were following the law and bringing this order forward. The court order stated that the library needs to provide a list of every person who checked out or used a set of items that has suspicious references to terrorism. And the law enforcement officer demanded the information right away, and it's a matter of urgency for an active criminal investigation. Now, the person who received this request at the service desk was not a manager and was a bit racked with their nerves. It's a bit nerve-wracking to receive this request. But then they remembered their library had a procedure to follow, and so they called the manager in charge. The manager arrived and reviewed the court order, and the first thing that they noticed is that the request is too broad, and it raises concerns that it's asking for too much information, because in order to comply with the request, the manager would have to violate the privacy of any number of patrons. And while the system that the library uses to store the checkout information, the ILS, doesn't automatically contain all their checkout information, patrons have the option to turn it on. And there's a list of about a dozen titles, and the court isn't asking for a specific person or group of people as suspect in this case. So the manager thinks that this is a request that needs to go through the director because it might be violating patron privacy laws. So following their policy and their procedure, then the director reviews the court order, agrees that it's too broad and has that potential to violate the patron privacy law. They escalate it up to their attorney for advice. The attorney reviews, agrees that it's too broad, and provides some advice on what to say to the law enforcement officer. In short, the library challenges the order, it goes back to the court, and eventually a revised court order is put out to provide the checkout information for just 2 individuals named in the court order. So then that speaks to that due process here. We do have to balance compliance with the law enforcement inquiry and make sure that we're protecting the privacy of our users, generally speaking. And sometimes law enforcement can have a great sense of urgency, but they are also required to follow due process. So it's a delicate balance and a challenging situation. Another scenario that I've noticed, so in my job at the State Library, I provide support for library directors and library boards. And a question I've received frequently since the start of the pandemic that we are still experiencing is about the tracking of patron data for contact tracing efforts. And many libraries have been asked by their local health authority to track patron entry to the library in case it is needed for contact tracing. And some libraries, I have heard, have actually been asked to hand over all of the tracking data to authorities on a regular basis, regardless of if it is needed for specific contact tracing efforts. And this is an area where libraries should tread cautiously. I did get a legal opinion on this, and what I heard is that it wouldn't be illegal for libraries to collect data about who was using the library, but you would want to treat this data as you would any other patron data with reasonable security protections in place, and only provide access to it when it meets one of the exceptions that's provided for by law. And so in the case of pandemic contact tracing, I've heard different approaches. It would be reasonable to share some of the information in the context of a specific contact tracing effort. Libraries have cited exceptions including the reasonable, safe operation of the library, the statewide public health orders, or by saying they would require a court order or a legal document to give over that information. But having to turn over all of patron data without cause seems like too broad of a request and makes it a questionable practice and not recommended. And also just one thing that was noted to me by a library was that their local businesses weren't required to turn over this information unless a contact tracing effort was in place with a specific individual or a specific date. And so again, you know, that broad request seems to be too much information to be sharing. So those are 2 kind of complicated scenarios where having a policy and really understanding these issues can be really, really helpful, and having then procedures that the director puts into place based on those policies. We'll get into more in that, on that regard in just a moment, but now it's time to have a bit of a discussion with you, and I'd like to hear, have you encountered any scenarios where having a patron privacy policy was in fact helpful, or where maybe you wish that you did have a patron privacy policy that would have been helpful if you had it at the time. And I'll also pause for questions here in just a moment too, because I see a question in the chat. And I see some people typing in here, so I want to give you time for that. And I know for some of you, you may be coming in and experiencing this topic with not a lot of experience from the library side of things. So those of you that do have some ideas or some experience here, I appreciate you sharing. Great, and I'm seeing some responses coming in now, so I'll just try to capture some of those. Great, so we have an example of a child attending a library program, and that child not being allowed to have contact with a set of parents or guardians, right? And so, you know, the policy helps clarify what information can be given out. And that's exactly an example that I hear a lot when we talk about this in terms of customer service. We don't know the actual relations between people outside of the library, regardless of their age. And so someone who's claiming to be a family member or claiming to have permission, we don't know if that's true or not. And so it's important to guard people's privacy for that reason. We don't know what custodial agreements or guardian agreements exist with children, with their parents. Great, and actually this is an interesting one here. Janet mentions the ability of patrons to take pictures on their cell phones of other patrons, and that can be disconcerting. And yeah, and that's something that I see sometimes addressed in a different, maybe not directly in a patron privacy policy, but in a policy that might address taking photos or video in the library, right? And it might also need to address privacy there. Sarah mentions examples including extended families and not being able to verify who that extended family is. Great, and John shares a helpful reflection here on an experience where in his work as a police officer, one day going to the library and looking for a suspect for a crime and feeling the frustration of being declined, but now in retrospect being able to see the reason for that refusal. And this is where I think communication and partnership with your law enforcement agencies can also help aid with this understanding, because it isn't that the library doesn't want to help solve a crime, an active crime or a crime investigation. It's that we have to balance those privacy needs of all of our patrons with the due process. And so, John, I appreciate that reflection you shared. Great, and Sue commenting on needing to ask officers to come back with a warrant for more information on a patron, and that put fear into staff. And this is certainly where policies and procedural guidelines can be very helpful for staff in helping them know what is clear. We'll share some examples of those in just a few moments. So these are wonderful examples, and it's the thing I like to say is that these situations are often very complicated, and it's a combination of policy and staff support on the operational side that really helps the library be successful in this area. And so we'll get into that in just a minute. I want to circle back. Tara asked a question about surveillance footage with, what about surveillance footage with court order for images of a particular patron? And again, I can't provide a legal opinion on this, but it does state in the law that patron records can be shared with a court order or other legal subpoena or other legal order. And so, you know, and with it being about a particular patron, you know, from what I have seen, often the need for those orders is that they need to be specific enough, so not for all patrons or for a 24-hour period of time or for ongoing access. Those things can be problematic, and American Library Association has some specific resources about surveillance footage as well. But, you know, with a specific request, again, if you have concerns about those sorts of things, you definitely want to check with legal counsel or somebody who is very familiar with the law and can advise you on that. And you also might want to consider that in your policies to make sure, are you addressing all the areas that are needed to be addressed. So excellent questions here. I'm going to keep us moving along. We'll have time for more questions and comments later on. So at this point, we're going to move into guidelines for policy development and look at some of the general principles here as well as some resources that will help you with your review and your revision process. So first, just a couple of frames here to help kind of think about the way patron privacy policy can work or should work. And I think it's really important with any policy you're setting to first determine the purpose of that policy. And when we talk about patron privacy policy, I see three areas here. First, you want to protect patron rights to privacy and intellectual freedom. That's really important. But you also want to protect the library by clearly drawing boundaries for what would be a violation of the law and also the values of our profession. So really setting that boundary for what the library can and can't do and clearly communicating that. And then third would be to create a document that helps guide staff decisions and guide operational decisions and also offer, I think, some protection for staff choices. So if staff need to make a decision and they know that it's in line with policy, then they're going to be backed up by the library, right? And so as long as they follow those policies and then whatever operational procedures relate, then they're on track for that. They're going to be protected. And then thinking about how governance influences operations, and this is just a chart from some of my other board trainings that I do, but really it's so important to start with the laws and the standards and values and ethics, and then the governing authority, which it might be your governing board for your library, or it might be your city or county, that they are going to take that information, and maybe you're an advisory board and you help advise on this process to the governing authority. Then that moves into policy creation that is approved by the governing board, but hopefully is developed in partnership with library director and library staff, and then that influences library operations. So this is kind of a smooth channel. We don't want to go the other way or jump around, right? We don't want to be setting policy if we don't understand the laws and the standards and values and ethics of the profession. And another way to look at this is to kind of see where, first of all, the line exists between policy and procedure. And so policy is set by the governing body for the library, and that might be the governing board, or it may be the library advisory board who is working through the city council or other administrative bodies, so you still have influence there. And then on the operational side, the library director is managing the operations and setting procedural guidelines for staff to properly implement the policy. But it's important that the board and the director, or the governing authority and the director, work together to make sure that the policies align with recommended practices and professional values. Now, some resources to help you out. The ALA, American Library Association, has a lengthy privacy toolkit that can be used as a guide for both policy development and also setting operational procedures. And the toolkit delineates some of the responsibilities for library boards as well as directors and staff. And so in addition to the responsibilities we've already gone over as far as like making sure you know the laws and the standards and the values of our profession, boards also want to think about make sure they're informed about issues relating to patron and user privacy and confidentiality, and that includes those specific to minors. Additionally, the board may want to understand the library's plan for communications in a crisis or in dealing with media should something arise that gets some press. And then library directors have many responsibilities around managing the operational procedures of the library, and one of those is to conduct a privacy audit to review and evaluate your current policies, your practices and procedures, and that includes vendor agreements and data that might need to be accessed by third parties for library operations. So what are your agreements there? The link to this resource, again, will be in the additional resources you get, as are the others I'm about to share with you. So you will get links to these tomorrow. Now, the Choose Privacy Everyday website, this is also created by ALA, and it really has a focus on raising awareness about privacy issues in libraries. And this site actually published several blog posts since the start of the pandemic that talked about some of the privacy concerns related to new and rapidly changing services being offered by libraries. So that's a good resource to check out, and they have some examples there as well. The Colorado State Library, my organization, includes a page with curated sample policies from public libraries, as well as a policy development checklist and template that you can use. One of our partners at the state, a statewide organization serving Colorado public libraries, is CLIC, the Colorado Library Consortium, and they have a public library policy collection that has an emphasis on small and rural library examples, so I recommend that as well. And then lastly, we have 2 blog posts on the Colorado Virtual Library blog site that directly relate to policies, policy development, and these were drafted by Colorado Public Library leaders after they presented at a conference in 2019. Amy Pila, the director of the Berthoud Community Library, recommends using clear and concise wording when a policy needs to be revised or written for the first time. She says, "We don't create policies to confuse people, but to help them. Staff should be able to sum up the policy quickly and have the full policy readily accessible." Susan Cadlock, who's an advisory board member at the Loveland Public Library, and Amber Green, who is the assistant director at the Loveland Public Library, recommend getting input throughout the process of policy development, and that includes staff that have expertise in the policy area and also from legal counsel. They say the deeper the level of feedback, the stronger your policy will be. So those are 2 really great short articles written by Colorado Public Libraries that you may want to reference. Again, links are included in the resources, so you will get to dive into those more deeply later on. So with that, we have just a few minutes right now for some questions if you have any. And I see there's a question in the chat, so I'm going to get to that. And so let me see what we have here, and feel free if you've got other questions to type them in. And Creed, I see your question here. I'm going to read it. And you know, we contract as a Colorado library with a service to provide your circulation services if or when they are hacked. Where does it leave patrons and the library in terms of recourse and protection? And that's very interesting, Creed. And I don't have a great answer, a great short answer, except to say that you will find some guidance in the fact sheet for protecting patron data that I mentioned. And that it really is, and what we are learning is that as professionals with our work in the library profession, we really need to be having conversations with our vendors about what happens if, because it's happening, the when is happening so much more frequently now. And so really getting clear on what level of security breach would be of concern and how you would handle that situation to be in compliance with the law. So that's a really good question. And I just see another comment in here, and somebody coming into the library and saying that they used to be in law enforcement and that they suspected a crime was taking place and they wanted to have access to library user records. And so that's a very interesting situation as well, and one where, again, if you were to receive a CORA request with that type of a request in it, that is not a court order or a subpoena, so check with your legal counsel to be sure, but those user records are not available to the public regardless of the reason for their request. I see a few more people typing questions in here. And I've got just another minute here, but I have more time for questions at the very end, so I may hold some of your questions for that time. I see a really good one in here, but we're going to come back to that at the end. And Tara makes the point that sometimes staff are concerned about better customer service than privacy. And I completely understand that challenge, and it is one where there's actually a version of this workshop I do that is focused on the customer service side of things because it's such a hard situation to navigate. So on the operational side, that's where I think guidelines from the library administration can be really helpful in setting boundaries for staff on what that customer service looks like. I've heard one person argue that, you know, is it good customer service to hand over somebody's information in a situation where it wasn't appropriate? We don't think it might be more convenient for that patron, but it's not customer service to the person whose patron's privacy, the patron's privacy that's being violated, and so it's perhaps a different way to look at that. And so, and again, we're going to get into some examples here, and you may see some ways that, you know, again, to help patrons learn how they can get their customer service needs met if they do want to share, allow somebody else to have access for their information. How do they go about doing that? So these examples come from some Colorado libraries, and I think they're really clear examples that you can pull from. They are all linked within the resources, so you will get the full text of these and can look at them later on. I'm going to show some screenshots, not expecting you to read all of them in detail, but so you can get a context of what it is we're talking about here. And following this is when we're going to hear from our mini panel, so we'll get to hear from some experiences from library leaders that are here today. So first up, I have this Estes Valley Public Library District confidentiality of library records policy, and this was first adopted in 2006 and reviewed most recently in 2018. And their policy is a strong example of a concise and clear policy. This is it right here. So it's just a few paragraphs. And one paragraph that stands out to me that's particularly important talks about the collection and storage of library use records. And it states, records that may be required for controlling the use of library materials, either on or off the library premises, are for the sole purpose of protecting library property. These records are not to be used directly or indirectly to identify the kinds of materials used by individual library patrons, except when the library can use such information to assist a patron in finding what she or he wants. When no longer needed for library administrative purposes, these records will be deleted. It's very clear about the way the data is collected and what it is used for. Estes Valley Public Library District also has a clearly organized staff procedure and also some training on privacy and confidentiality. And this document was created by the library director, Claudine Perot, with input from managers and staff. And one aspect of this procedure, which is particularly helpful, I think, is the section on privacy in practice, which helps guide decision-making for library staff. Unsure about an exception to the law? Talk to your supervisor. Law enforcement asking about patron data? Officers need a court order to access patron information. Respectfully connect them to the library director. Family, friend, or officer looking for someone? We don't disclose, so offer to page the person or invite them to walk around the building themselves. So just some clear guidelines there. Now, the Mesa County Library District has two policies linked to patron privacy. The first is their privacy and confidentiality policy, which was adopted in 2019. And this has two sections worth noting. The first states that Mesa County Libraries will take reasonable measures to ensure the confidentiality of each patron's MCL record, account, and library use by securing and limiting access to these records. And so this is an important clarification linking both the Colorado Library Law and the Consumer Data Protection Law. And the other section here that I wanted to call attention to is just explicitly stating the access that parents are granted to, the level of access that parents are granted to library records of children. And it states that MCL respects the privacy of all patrons no matter their age. And then it goes on to outline that a patron must have the child's library card in order to access information about the child's account. So that's their rule. And then they also have a library card and borrowing policy, which includes a reference to the confidentiality of the library record. And this addresses that a library card must be presented to access information on the account, even for children's accounts. And so in doing this, it's putting that privacy information in a location that's convenient to the patron that they might be viewing when they get the library card or when they're signing up their child for a library card. Now we have Shauna Wade here from the Mesa County Libraries today, and she's going to share some of her experience in just when we get to the next section in just a moment. So more on that in a moment. The last example I have is from the Loveland Public Library, and this is a municipal library. And we also have Susan Cadleck here today, who's on the board for the Loveland Public Library, and she'll share some of her experience as well. But in this policy example, I just want to call attention to the section where they outline more specifically what information is collected and stored that is considered part of the patron's user record. And so some of the things that are in this list are that physical items that are used either in the library or checked out for use at home or outside of the library, anything about the patron record really, use of computers, and it names all the locations of the library where computers are available, information conveyed during a reference interview. So if somebody's asking a question verbally, that information is included. Use of library meeting rooms, and also use of library Wi-Fi. And I'm going over that just briefly to give you a sense. There's more detail there as well. So it's just helpful for staff to understand what it is they're required to be protecting. So now that I've gone through those examples, I realize rather briefly, but again, you'll get a chance to look at those in more detail once you get the resources. Now it's time to hear from our two library leaders who are here today to share their experience with policy development and a little bit about their library's approach. So joining us today, we have Shauna Wade, Associate Director for the Mesa County Libraries. Shauna has served as an interim director there on several occasions and has worked closely with the Library Governing Board on policy development. We also have Susan Cadleck, the an advisory board member for the Loveland Public Library, and Susan was very involved in their most recent policy review cycle and has presented on policy development at our state conference for libraries, and she co-authored one of the articles I mentioned earlier. So Shauna, we will hear from you first, and I just would like to know, your library has reviewed and updated your patron privacy policy recently, so will you tell us a little bit about your approach to the review and updating of those, particularly the patron privacy policies?
Hi, good afternoon. Sure, Crystal. Yeah, so we updated our patron privacy and confidentiality policy in July of 2019. And we review our policies every 3 years. We're on a 3-year kind of review cycle for all of our policies. And so I knew that in 2019 the privacy policy would be updated. And so I started preparing earlier that year. This policy is one of the more in-depth and complex policies that we have. And I also knew that there had been a few different changes with the addition of the Consumer Data Protection Law and increasing focus on privacy, that I wanted to make sure I did a really thorough job of researching and background information. So in April of 2019, I took a 4-week online class through ALA on privacy, libraries, patrons, and the law, and that gave me a really good foundation of understanding the legal information, a lot of what you've covered at the beginning of this presentation. And then I also attended a webinar called PrivacyCon, and that was put on by the FTC, and that was really interesting to hear kind of outside of libraries and how industries approach privacy policies, disclosures, and permissions. So doing a lot of background information. That year, we were also lucky enough to have a board training, and so had Crystal come and do an on-site training for our board, and part of that was covering some of the general information that she's shared today with our board in person. And I think that really helped give our board members a background in library values and regarding to privacy and some of the legal information. It's an interesting dilemma to have enough information in your policy to cover all of the different details. I wanted to make sure that I covered the information on the consumer data protection and having a data disposal section on there, and also covering the legal aspects and what parents and children, what their rights are and what they would be able to access. And also, like, one of the biggest challenges we run into is third-party access and how much we can actually control. There's a lot of that third-party. Once we connect people to Overdrive or to Canopy or LinkedIn Learning, we no longer have a lot of access. So wanting to make sure that we had a section in our policy that educated our patrons about third-party vendors and what we could control and what we couldn't. And so a lot of our policy is educational, informing patrons about what information we collect, how long we keep it, and what third-party vendors might have access to, and then a little bit about what their responsibility as patrons are, and then also to help guide our staff in implementing this and how they can conduct everyday transactions. You know, most of the time we don't, you know, I think I've had law enforcement come and ask for information less than a handful of times over the last 20 years. But we get parents all the time wanting access to their children's information or a spouse's information. And so balancing our procedures for how to maintain privacy in those situations, because you never know what the home situation is, who the custodial parent is, or what the marital status of somebody is. So having those really practical procedures in place, but also having your policy informed enough so that when you do have law enforcement or a bigger issue, that it's clear on that as well. So in July, we passed the policy. We reviewed it with with the board. Some of the things that they were concerned with were examining how parents could access their kids' or teens' accounts if needed, but also making sure that we had protected their rights and their privacy. We also talked about how we secure information, and we're looking at the possibility of implementing PIN numbers, which right now we can't do because we're part of a consortium, so that's a bigger conversation. But they were really interested in what we were doing to secure our networks and how we protected the information that we do collect. And then what we would do in case of a data breach. So that was kind of some follow-up information after passing this policy. And that's our process. I look forward to answering any questions here in the chat later.
Yeah, Shauna, thanks for sharing all the context also behind how you approached the policy review and revision. So I think that's very interesting to hear and hopefully is helpful to some people here. So Susan, now I will ask the same question of you. Can you tell us a little bit about your library's approach to the review and updating of patron privacy policies? And it looks like we just need to unmute. There we go.
Hello, everyone. Sorry about the tech glitch. As a trustee, my first concern is intellectual freedom, but my second really is patron privacy. So I volunteered to help with Loveland Public Library's policy revision in 2018. And our committee was comprised of librarians, other staff members, and we had 2 library board members. On the committee, our starting guidelines for patron privacy were ALA's statement on patron privacy, the state library resources, which were really very, very helpful, and also state law. And we began the process by reviewing these documents. We were very fortunate in that our committee chair was Amber Green, our teen librarian. And as such, we were especially concerned with privacy with respect to minors, as has been mentioned several times already this afternoon. And it generated a lot of discussion. We were very fortunate that we were ably assisted by our city attorney, who knew the latest laws with respect to teen and parental rights. So that really provided a lot of guidance for us. And we felt very comfortable with our final document that it was an even balance between both of those aspects. We also were talking about privacy with respect to the Americans with Disabilities Act. That was another big issue for us. And we decided that service animals as defined by the Act were allowed without any intrusive questions on the part of staff, and asking about a person's disability is not permitted, and that's a procedural issue, so it's not written up in our policy. We also were very, very concerned about privacy with respect to Internet usage and made sure that that was part of our revised privacy policy. The staff was briefed on patron policy, including the need for police to have a subpoena or some other kind of court order, again, as this has been mentioned several times already. And in the case that the police does come in with that document, the staff still needs to contact the city attorney. So we're jumping beyond supervisor, beyond library director. We're going right to our city attorney with these kinds of questions. And this has happened a couple of times already in our library. And the big exception to this would be if there's a case of a minor that's in peril, in which case it's clear that there needs to be cooperation with legal authorities. And our committee really tried to envision any circumstance where there might be a potential conflict with patron privacy. And we really did a lot of brainstorming, and I think that having 2 board members on the committee really helped with that, because we could provide a different perspective. We weren't so concerned with customer service. We were concerned with the rights of the patrons. And not that our library staff weren't also, but that was our first priority as board members. And we actually spent as much time easily on patron policy as we did on drafting the whole new sections dealing with makerspaces. That was how critical patron privacy was for us at the Loveland Public Library. And that's the end.
Susan, thank you for sharing your experience. And of course, coming from a municipal library, it was a little bit different than the governing board in a library district. And so it's great to hear that how those are different. So thank you so much for sharing that. And I will say that if anybody attending has questions for Shauna or Susan, or just general questions, you can put those into the chat, and we'll try to get to those. And if we can't get to them during the recorded session today, maybe we can follow up with you later. I do see that Sarah had asked a really great question. What would you consider the biggest challenge to library patron privacy? And I'll actually put this out to everybody here. If you have a thought on that, I would love for you to share that in the chat as well. From what I've seen as I monitor this issue at not just at the state level, but also at the national level, I hear, I think, 2 themes coming up. One is that technology has advanced so much, and where we are, as someone mentioned earlier, we are giving so much data to companies, and we aren't always aware of how they might use that data or sell that data, and so we in effect don't own it anymore. Or when something is posted online, it's very hard to remove it from online. So you might think something is private, but then in actuality it becomes more public. So there's certainly lots of media scandals around that sort of thing. And so the technology itself, as it gets better, creates more challenges for privacy, generally speaking. And there are certainly some webinars we've hosted at the State Library, but also that our national associations have hosted on this topic if you're interested in learning more about it. The other big challenge that I see is that people, as our use of technology changes, as people become more comfortable giving over some information, whether it is for security or convenience or fun, people's perception of why privacy matters has changed. And so library patrons don't always understand themselves why privacy is such a big deal, and so and why it's something that matters to libraries so much. So I think that's another side of that. So. And I'm looking at the clock. I'm going to gently start moving us into our wrap-up, but I see so many people typing. So I'm going to watch for questions and try to weave those into my wrap-up or catch them at the end as I see them. But there's also another thing I'd like to ask you to consider at this point as we move into the wrap-up, is just for you to reflect for a moment as you're probably going to go and do something else in your evening tonight. Before you do that, what's one thing that you've learned that you will incorporate into your work with your library board or with your library staff, for those of you who are on the management side of things? So what's one thing you've learned? And you're welcome to share it in the chat. You don't have to, but if you're comfortable sharing, would love to see that come up in the chat. And also I will be emailing out this handout with links to resources on it, so that you will be able to access all of this information. That should go out to you tomorrow morning, so yeah, you won't have to wait too long for that before you can access the rest of these resources. I do have an evaluation. I would love to hear your feedback in a survey about today's session. So if you have just a few moments before you go on to your next thing, it just takes a couple minutes to fill that out, and it helps me improve and helps me know what worked well and what didn't work well. I'm seeing some really great things in the chat. I still have just a few more announcements, but let me see if I can capture what you're saying here. I see that, challenge being that working with so many third-party vendors for digital resources, that is absolutely a big challenge. And then what happens when you think there might be crimes happening in the library, fraud, for example, and how does the library handle that? That is certainly a really challenging situation to face, and brings into question what is the appropriate role of library staff when that might be happening, and certainly a challenging thing. Convenience versus privacy being very difficult, and I see somebody saying they want to check to see that their policies are up to date. Check with your board on things. So great thoughts that you're sharing here in the chat. So yes, please fill out this survey if you would, if you've got a few moments to do so. I'll send out the link with the resources in the morning as well. I mentioned the Colorado Virtual Library blog, and the Trustee Corner newsletter is a great resource. If you're not already signed up, we have an email list, and that's how you get notified when a new Trustee Corner is out or when a new training is announced. So I'll include that link as well in the follow-up email tomorrow, so you can sign up for that if you would like to be up to date about library trustee information specifically. We do have a couple of upcoming trainings that I wanted to make you aware of. In case you're interested, save the date. So Library Board Essentials, this version of it will be for governing boards. It's Thursday, November 12th at 10 a.m. And this is great for new trustees, but also for continuing trustees who want to brush up on knowledge. And then the second event is called Trustee Talk, and this is a discussion meetup, and our topic for November is library values and ethics, and that will be Thursday, November 19th at 4 p.m. And both of these events have limited capacity, so watch for an announcement on the Colorado Virtual Library and the COLT email list if you are interested in signing up for those. So with that, I share my contact information with you. I just want to thank you for joining me today and for being a part of this learning and this conversation about such an important topic of patron privacy. And so don't hesitate to reach out if you have any questions or would like to talk about this further. I wish you all a great evening, and thank you again for being here.